Hey there, everyone. Josh Crowfoot here, Crowfoot Law Firm in Chattanooga, Tennessee. I'm a commercial real estate lawyer. We're here on day 17 of Commercial Real Estate 101. And today we're going to be talking about default provisions in a contract. And so, what are default provisions? They are the provisions that give your contract teeth when another party violates the contract. In terms of violation, that could be a failure to perform a certain obligation, could be a failure to perform a certain duty, could be that the other party is required to satisfy a particular condition and they don't have that condition satisfied, could be a host of things that are defined in the contract or not. Typically they are, and they're defined as what's called an event of default. And so what are the remedies that a party can have? Well, on the buyer side, if the seller breaches, let's say that the seller decides not to sell the property to the buyer can sue for damages typically, or sue for specific performance. Specific performance is what's called a remedy in equity. It's basically giving the buyer the ability to force the seller to sell the property to him or her. A smart seller will not agree to allow the buyer to sue for damages, since that's pretty open-ended. But what they might agree to is offering to reimburse the buyer for all of the money that they've outlaid in the contract, that they can provide reasonable documentation for due diligence expenses, attorney expenses, third-party costs, survey, appraisal. The seller, if they're savvy, will offer that up instead as a means of making the buyer whole in terms of a breach of contract. On the seller side, typically what is given to the seller is the ability to hold on to the earnest money and not have to give it back. So the seller can terminate, enter into a contract with the new buyer, and then move on. I hope you found some of this helpful.